Hi, everyone. Let me go back to the beginning here. This is a quick review for you guys for Unit 3. This does not encompass everything in Unit 3, but as we come in for exam, this is targeted in some areas to help you prepare. This should not be the standalone way that you review, right? You should go through your notes, go through the former videos, maybe find ways to practice some things, some questions. But if any of this to you, you're like, oh, I'm not sure about this, that will help direct you in an area maybe to focus on a little bit. So this unit's all about civil liberties and civil rights. So let's start right with the First Amendment. Congress shall make no law respecting an establishment of religion, of prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people peacefully to assemble and to petition the government for redress of grievances, right? So there's a lot in this First Amendment. You can petition the government and complain about stuff. You can gather together peacefully to protest. You can speak. You can print, you can pray, right? All these things. Let's talk about some of them. Why are these Bill of Rights? Remember Scholastic? That was pretty cool, right? What's the purpose of at least the first 8, and then the 9 and 10 go on? But the idea is that everyone in nature has these rights, whether it's by God or the universe. But you see this in our documents, and they're inalienable, which means the government can't take them from you, and you can't even give them up yourself. You can't even give up your right to free speech, right? You might not use it, but you can't give it up, right? And that's why the Anti-Federalists were so insistent that this has to be included in the Constitution, because they really thought of this as the foundation of what our government should be based off of. And we saw how this played out in the courts, especially through the civil rights movement. We looked at Engel v. Vitale and freedom of religion. This focused specifically with the Establishment Clause, that the government can't have an established or mandatory religion. So remember, there's the free exercise clause and the establishment clause. You should know the difference of the two. And then lovely cutoff here, Congress shall make no law respecting an establishment of religion, right? That's the establishment clause, or prohibiting the free exercise thereof. We saw some of the C-SPAN landmark case video. Maybe you went back and saw the rest. There is Mary Beth Tinker in the right, celebrating 50 years, not too long ago, of the passing of Tinker v. Des Moines. Remember that this said that students did have the right to free speech, and that symbolic speech, so wearing those armbands, were included in that. We also see the Fifth Amendment, which goes, if we pass after the First Amendment, grand jury, double jeopardy, self-incrimination, due process, all those things. Self-incrimination is what also created the Miranda ruling, right? That your Miranda rights. We learned all about Miranda and what his deal was. No question will be about who died in a bar. So just so you know. We also have then the Eighth Amendment dealing with cruel and unusual punishment. And even in your review videos, I'm being timely, because here, just today, the Supreme Court said they reimposed the marathon bomber. You know about this case? I don't know. You were probably so young when the marathon bombing happened, but they were throwing out his case, possibly because of evidence that wasn't introduced. And then today they said, no, like it can go forward. There is a death penalty in the federal government. There's not one in New Jersey. The Supreme Court has ruled that they do not think the death penalty, if done correctly, violates the amendment for cruel and unusual punishment. But there are some justices, I think this ruling was 6-3, that still believe that it does. So Breyer, the one who's retiring, right, one of his last dissents here, he wrote, I have written elsewhere about the problems inherent in a system that allows for the imposition of the death penalty. This case provides just one more example of some of those problems. So he doesn't believe the death penalty should be legal at all, and he just said this is an example, right, of like, what if you had this wrong? right? Um, and as we looked at all these rights, we also learned that all these rights still have regulations, right? Even the freedom of speech has limitations. The freedom of assembly has limitations. You can't protest on someone's private property, right? So how we balance individual liberty with order is being a key component to how we succeed. We also learned the 14th Amendment helped secure those rights so that they could trickle down from the federal government to also the state and local governments. And we saw lots of other court cases that dealt with this. Gideon, right? Gideon was an example where your right to counsel, your Sixth Amendment, had to be brought down from the federal to the state level so that because he didn't have a public defender at his initial trial. Well, we also see Roe v. Wade and the right to privacy, and how that exists comes from the Fourth, Ninth, 14th Amendments, right? How the right to privacy is all in there. And also noteworthy is not the Supreme Court, but Florida court said yesterday, I think, that abortions after 15 weeks were banned. So will be molded into how the Supreme Court confronts these issues in the fall if these state rulings violate those amendments and the right to privacy. We also learned historically how some of these rights were then enforced from the social movements and then utilized by both the executive and legislative branches, not just the judicial branches through these court cases. Right? We learned how the Civil Rights Act helped enforce the 14th Amendment and making sure everyone had both due process and equal protection. How the 14th Amendment helped to finally outlaw all these Jim Crow laws. And then you have the Voting Rights Act of 1965. And then you have also things like Title IX, which helped advance equal protection and due process for lots of things associated with women, such as the women's sports, just like the 19th Amendment gave them the right to vote, and other things helped with women equality as well. We studied a good day plus, right? A lot of things to do with Brown v. Board. That is what the FRQ would be around. So if you're not too sure, the facts of Brown v. Board, you want to spend some time with that and how Brown v. Board overturned the crazy idea from Plessy versus Ferguson that separate but equal was a thing. They said, no, that totally violates the 14th Amendment Equal Protection Clause. And lastly, this unit we talked about affirmative action. The basics of affirmative action, how it can work and what can't be done. For example, a quota system is not an acceptable use of affirmative action, but using race as part of a whole can be. All right, so it is March, St. Patrick's Day coming up, so you should have all the luck with you right now, and you don't need luck. As long as you prepare, you got this. All right, see you guys. Have a great weekend.